Do you know what requests to charge are? You don't? Come join me as I share with you exactly what they are. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. At the end of a trial, before giving closing remarks, we have to give the judge a list of various areas of law that we want the judge to instruct the jury about. That's known as request to charge. Your Honor, we're giving you now a list of our requests to charge. And now the judge has to go through our list of things that we want the judge to talk to the jury about, and our adversary will also do the same exact thing. And they're going to be different. The defense attorney is going to come in with a different set of instructions that they want the judge to tell the jury about, and we are going to have specific requests that we believe are favorable to our particular case and our position. And now, during what's known as a charge conference, which is a conference held in the judge's private chambers with a court reporter, a stenographer present, now the judge will go through and hear argument from the attorneys about why he should or should not give specific instructions on the different requests that we are asking. So during this particular conference, the judge will ask us, okay, Mr. Attorney, why do you want this particular charge given? And now the attorney has to give an explanation. And now the adversary will have an opportunity to give his response as to why that particular area of law or that instruction should not be given. And then obviously the judge has to make a decision. And now we go through every single particular request made, and the judge will either agree or disagree. He'll go through our list first, then he'll go through the defense attorney's list second. And then at the end, he's now going to say, okay, now we have all of the requests to charge. Here's what else I'm going to be instructing the jury on. And why is this done? It's done for the key reason that before going ahead and giving closing remarks, the attorneys are fully aware of what instructions the judge is giving to the jury about what the law is in this particular case. And that's critical so that now the attorneys can actually comment on some of the law and some of the instructions that the judge is going to be giving. Now we can address the jury and tell them, listen, the judge is going to give you specific instructions about what it means if a witness has been found to have lied and if you determine that a witness has lied. So now when the jury actually listens to the judge's instructions, they're going to be tuned for it, and now they're going to pay closer attention as the judge gives them a particular instruction about what we just talked about. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into the trial process, into the litigation process, in a medical malpractice case, in a wrongful death case, in an accident case. And you know, I recognize that you probably have questions of your own about your own particular matter. Well, if your matter happened here in the state of New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I welcome your call. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.